today with Professor Blackman about the future of the Supreme Court following the death of Justice Scalia. You may know originally we had a different topic planned, but this was timely, and thank you for coming out. In fact, before the day's over, if you want to shoot us an email, before I email, let us know if mornings are good, bad, difficult, easy. Also locations. We're looking at some Virginia Beach locations and some downtown venues as well. But our event today is being hosted by the Hampton Roads Lawyers Chapter of the Federalist Society. And the Federalist Society was founded on the principles that the state exists to preserve freedom, that separation of powers is a good thing, and in fact it's central to our Constitution, and that it is emphatically the province and the duty of the court to save the law and not what the law should be. So with that as an introduction, our speaker today is Professor Josh Blackman. He comes to us from Law in Houston, where he's been teaching. He teaches constitutional law and property law, but he does very many other things, including publishing prolifically. You go online, he's got his blog, joshblackman.com, and his CV is very impressive. I think 28 articles just in the last 4 or 5 years.
He can count high. Very good.
Yeah, I can count. It's a big number. I was very impressed. But on a breadth of topics. And aside from that, there's some other important things to know. The attorneys in the room, you all know that clerking is a big deal. He clerked at the Sixth Circuit as well as at the district courts. He has testified in front of the U.S. House of Representatives Judiciary Committee on the topic of executive action in the realm of immigration. And he's done some other things too, but the thing that really got my attention was what he did outside of academia in the purest sense, at least at the law school level. And that is, he is the co-founder of the Harlan Institute, which leveraged fantasy sports in the Supreme Court context. He's got a teaching tool for high school students to expose them to the Constitution, the rule of law, and really how our court works using live Supreme Court cases. And so if you're interested, check out fantasyscotus.net. But that's something he's doing beyond the law school classroom to really affect students across the country. To me, beyond just a professor, we have another professor in the room. Professors are great, but he really is in the realm of teacher too, beyond that high level of law school, which is really unapproachable for most of our fellow citizens. He's reaching out through other venues to high schools. And so I was very impressed by that.
Thank you.
Law professors use that as a teaching tool too.
Maybe some law professors in this room, in fact.
Yes.
So without stealing any of his thunder, you know the topic, and we have both a professor, a learned man, I think
Thank you.
describes a polymath by a Pennsylvania paper, which is very impressive. Since
What is Pennsylvania, right?
Which Ben Franklin's from there, so it means something. They use that term. But take a look at his CV. You'll see there's some articles that you might want to check out. So I give you Professor Josh Blackman.
Thank you so much. You can clap. Please clap, right? Please clap. I thank very much to Elizabeth and Chris for inviting me here, and my friend Tessa, who invited me to Regent later this afternoon. It's with some sadness that I'm even here. I really wish I had a different topic to talk about, but I don't. I wish this topic would be one of abstraction, of hypothetical, of how the Supreme Court will be shaped, but it's not. And I'd like to begin with just a brief moment of silence for the loss of Justice Scalia. This is actually a picture from his memorial to court last week. You can see the other 8 justices standing from his flag-draped coffin. And just take a moment to reflect on everything Justice Scalia has done and his family and friends. Thank you. Actually, this past weekend, the Federalist Society held a banquet dinner at the University of Virginia in Charlottesville, and Justice Scalia was supposed to be the keynote speaker, and he wasn't. And in his place was actually Paul Clement, one of his most famous law clerks, who's been the Solicitor General. And one of the treats was after the event, they had one of Justice Scalia's daughters. He has 9 kids. One of Justice Scalia's daughters came by, and her name was Meg. She's very gracious, and I told her a story. I mean, we've all been touched by Justice Scalia in different ways, but I have one story which I like sharing. When I was a law student in Virginia at George Mason, I'm a member of the Virginia Bar. I'm barred here. We got the chance to see Justice Scalia fairly often. He did lots of events. So I went to one event, and I bought a copy of his book with Brian Garner, and he signed it. He was very gracious. Then I said, you know what? I'm going to see him again. I already have a signed copy of his book. I don't need another one. I want to sign my Constitution. So I, wait in this long line, it's like a 30-minute line. I get to the end, it's like, Justice Scalia, would you please sign my Constitution? He's like, nah, get out of here. He says, scram, get lost. So I was like, okay, fine. I was thinking about another book event later that summer. I say, Justice Scalia, would you please sign my Constitution? He's like, no, get out of here, right? This is, the Sicilian wave. He says, get out of here. So then I get smart, right? I know that Justice Thomas is coming to my law school because one of my professors was a Thomas clerk. So I go to Justice Thomas, will you sign my Constitution? He says, of course. He sits there, he puts a signature in it, writes a very nice message. So at the 2009 Federal Society Lawyers Convention in Washington, Justice Scalia was slated to speak again. And I'm like, okay, here's my shot. So I sit again in this long line. I get to the end. I'm like, Justice Scalia, will you please sign my Constitution? And Justice Scalia says, no, get out of here. But then I open it up. I go, Justice Thomas signed it. He's like, all right, give it to me. And, and he scribbles signatures like, all right, now get out of here. This was a beautiful man, a great man. I told this story to his daughter, and she was laughing hysterically. She said, we have to be very persistent with him also. So this was a great man, and his loss will be felt not just in the court, but in our nation as a whole. He has done so much to promote textualism, originalism, and a commitment to the rule of law. And I hope that all of us as attorneys and not educators of the Constitution can help keep his memory alive by teaching his opinions, teaching his dissents, and hoping we can inculcate and develop a new generation of thinkers who can maybe one day approach the greatness that is Antonin Scalia. I'm not too optimistic, but we can all hope and try for that goal. So for the rest of the talk, I want to discuss the selection of the next Supreme Court justice. And again, this is not a hypothetical. On January 20th, 2017, there's a very strong chance that there will still be there will be 8 justices, and there'll still be an MTC in the court. And whoever Chief Justice Roberts swears in next will have the chance to appoint to the court 1, 2, 3, and maybe 4 justices. I used to have Justice Scalia's photograph in that lineup, but I had to take it out. It feels somewhat odd. But the next justice may have, even Justice Breyer will be 78. And if Justice Scalia's tossing, I think, is that life is short and tragically short. So what we have to appreciate is that over the last 40 years, at least since the Burger Court, virtually all of the justices have been appointed by Republican presidents. Virtually all of them. There have been very few. And on the Burger Court, the Rehnquist Court, and now the Roberts Court, the majority of the presidents have been Republican. Only President Obama and President Clinton have been able to appoint justices. Carter had none. And of the 16 justices that they appointed, okay, these 16 all but 4 were appointed by Republican presidents. So you think, right, if I can break it down so crudely, you would think that if there are 4 justices appointed by Democratic presidents and 12 justices appointed by Republican presidents, then the Supreme Court would be a fairly conservative institution. That various aspects of originalism, textualism, understandings of limited government, understanding of enumerated rights, enumerated powers, you would think that our courts of jurisprudence would reflect the fact that you have a majority of justices appointed by Republican presidents. But this hasn't been the case. And I'll humbly submit to you, this has not been the case because for the most part, Republicans have not been nearly as successful in appointing justices. So I'm going to show you a graphic. It's going to shift real quick, right? So this is the raw number of justices appointed by presidents, right? This is what it actually looks like. Let me do it again. You missed it. Ready? 1, 2. 1, 2. Okay? You actually see that a significant number of the Republican justices have moved to the left, and a significant number of them have moved to the middle, somewhere liberal, somewhere conservative. Very few of the justices appointed by remain on the Chief Justice because he breaks my heart every year. And I have a feeling he's going to really break my heart this year in ways I can't even fathom. So this history of appointing justices led me and Randy Barnett to write an article in the Weekly Standard in September, before any of this stuff happened, discussing 5 lessons for a Republican president to consider when making the next Supreme Court nomination. These lessons have become so much more poignant in light of Justice Scalia's passing because, again, this is not some sort of hypothetical. This is not a drill, right? This is, my military friends, this is not a drill. This is DEFCON 5, right? This is legit right now. And 5's the highest, right? Yeah. People always think DEFCON 1 is the highest. I think 5 is actually the highest. So the first lesson, and this is a lesson which I think history teaches us, is that these bruising confirmation battles are worth it. They are worth the political capital for a lifetime appointment. And if you look at what's going on in Washington now, I think that's testament to the fact that the Republican leadership in the Senate is saying this is worth the political capital of fighting. So our story begins, at least in the modern era, when President Reagan in 1987 nominated this man, Robert Bork, for the U.S. Supreme Court to replace Justice Lewis Powell. Now, Powell was a moderate. Bork was a conservative of the highest order. And when Reagan nominated Bork to the court, I don't think anyone in the White House, as smart as they were, anticipated what would happen to the Bork nomination. The confirmation hearing of Robert Bork became legendary. In fact, he even coined a verb, to bork, which now means to block a judicial nomination. Why? Because people like Ted Kennedy and Joe Biden, who were then on the Judiciary Committee, recognized that replacing the moderate Lewis Powell, who voted to uphold Roe v. Wade, he was in the Roe v. Wade majority, to be replaced by Robert Bork, who, to put it mildly, would not have voted to uphold Roe v. Wade, would have radically shifted the Supreme Court in ways. And Ted Kennedy famously said, in Robert Bork's America, women are getting back alley abortions and all these sorts of charges. For the first time ever, a justice was voted down because of ideology. I mean, there have been justices voted down because they thought they weren't competent or they were corrupt, but this was really the first time where a justice was voted down straight up on ideology. No one doubted Bork was a smart man. He was a law professor, a solicitor general, a court of appeals judge. He was qualified for the job. But Biden, and you can see his speech, he has lots of speeches recently that have come out, but Biden's speech said, we are doing this because we don't think ideologically he's a good judge. Shortly thereafter, after Bork was voted down, President Reagan appointed this man. He never actually appointed him, but he selected him, a guy named Douglas Ginsburg. Ginsburg was actually one of my professors at George Mason. He was a Harvard law professor for many years, a judge in the D.C. Circuit. Unfortunately, it soon came out, due to the enterprising work of Nina Totenberg and National Public Radio, that Doug Ginsburg had smoked marijuana with students. Now, there was actually a time where smoking marijuana was a disqualification for public office. Today, it's likely enhancement for public office. And before Ginsburg was ever actually officially nominated, President Reagan had him withdraw his candidacy. And then they were scrambling. With less than a week left, President Reagan scrambled and picked this man, Anthony Kennedy, what we might call a Sacramento Republican. And you can see Attorney General Meese standing off to the side. Kennedy was in every respect viewed as a moderate. The people in the Reagan Justice Department said, you know what, we can't fight this anymore. You know, we can't do this anymore. We got burned with Bork. We got burned with Ginsburg. Let's just put up a moderate. And Joe Biden and Ted Kennedy were like, oh my God, this is awesome. Kennedy sailed through. I think the vote was 97-0. If that should have been the first indication something was awry with Justice Kennedy, it was the fact that he was confirmed 97-0 after they voted down Bork and Ginsburg never even got to a hearing. I don't need to explain to this crowd the consequence of having Anthony Kennedy in the court instead of Robert Bork. We would have a very, very, very different world. and I don't just say America, a different world indeed. Planned Parenthood v. Casey would have never happened. Lawrence v. Texas would have never happened. The Guantanamo cases probably wouldn't have happened. They may have. Just go down the list of all the cases where Kennedy was a fifth vote and replace it with Robert Bork. And this would be a very different world indeed. Forget about same-sex marriage in Windsor, but because by that point we've probably had new justices, but we would be in a very, very different place. The next major candidacy for the Republicans was when William Brennan stepped down. He was quite old, he was infirm, and he couldn't live any longer. I don't say this lightly, but he really wanted to live until a Democratic president, and he couldn't make it. So he stepped down during Bush 41, during H.W. Bush's presidency. And at this point, Biden and Kennedy realized that, replacing Powell with another Republican was bad. Replacing the Lion, William Brennan, with a Republican, that was devastating, right? That was awful. Now, it fell to then President George H.W. Bush to appoint a justice to fill the seat of William Brennan, the great justice, right? The great liberal Lion. Now, this is actually Bush with his chief of staff, John Sununu of New Hampshire. And at the time, H.W. was focused on other things. He did not make the Supreme Court a priority. He did not want to fight over the Supreme Court. He did not want to have a bruising confirmation battle. So he sought to nominate a stealth justice, a justice who could sneak through under the radar, be a solid conservative, or at least as conservative as George Bush ever was. Unclear how much that was. And get him through without a bruising fight. Now, Senator Cruz, who I'm supporting, often tells the story where President Bush had the choice of nominating this guy, a guy named David Souter, a fairly young Court of Appeals judge from New Hampshire, or another judge named Edith Jones, who was a conservative Reagan appointee in Houston, where I live now. And President Bush reportedly said, I don't want to pick Edith Jones. It'll be too much work. It'll be too complicated. So we went with Souter. This is actually Souter and Senator Warren Rudman, who was from New Hampshire, who also backed him. The problem with Souter was that no one knew what the heck he stood for. He had been a Court of Appeals judge for about a year. Before that, he was on the New Hampshire Supreme Court. And he frankly had no record. But everyone told him, this is John Sununu and Rudman Gray and all these other people. I'm sorry, Warren Rudman and Boyd and Gray. They said, listen, we know this guy, right? He's solid, right? We know in his heart he's a conservative. I don't want to ever hear from anyone else that we know in his heart he's conservative. I want proof. But President H.W. appointed David Souter. Even the media was like going, who the heck is this guy, right? What does he stand for? Biden and Kennedy were like, oh, are these fools doing this again, really? And Souter, they gave him some, angst during his hearing, but he sailed through. I mean, there wasn't much opposition because, again, the Democrats realized they dodged a bullet. Fast forward another year, and Justice Thurgood Marshall, the great civil rights champion, passes away. Now, if the Brennan nomination was big, replacing the first African-American justice was going to be even bigger. And this was going to occasion a massive fight. And I think when George H.W. Bush made his appointment of Clarence Thomas to the U.S. Supreme Court, I don't think he appreciated exactly what would happen. I don't think he appreciated the depth to which there would be opposition to this man's ascendancy to the Supreme Court. At the time, Thomas was a fairly young man. He had been the commissioner of the Equal Employment Opportunity Commission. He had been a judge in the D.C. Circuit for less than a year. In fact, there's some speculation that he was put on the D.C. Circuit to replace Thurgood Marshall, but they didn't expect it to happen quite this quickly. So the Thomas confirmation hearings, which are now the subject of an HBO movie starring Kerry Washington called Confirmed or Confirmation or something like that. I'm not going to watch it because I know exactly they're going to appear, were characterized by, again, Joe Biden. By the way, Joe Biden's greatest contribution to American history is not as vice president. His greatest contribution to American history is as chairman of the Judiciary Committee for the Bork, Kennedy, Souter, and Thomas confirmation hearings. That dwarfs anything Uncle Joe's ever done in the White House, by a lot. So shortly after the Thomas confirmation hearings began, Biden and others attacked him. One of my favorite lines of attack from Joe Biden was because Justice Thomas had read Richard Epstein's books on takings, one of the greatest books in the 20th century on property theory. And Joe Biden said, anyone who reads Richard Epstein is not qualified to be in the Supreme Court. Speak for yourself. But what really sent Biden's hearing over the edge were the accusations of Anita Hill. Anita Hill was a employee at the EEOC who had worked underneath Thomas, and she charged that he sexually harassed her, that he made these lewd statements, that he had a can of Coca-Cola with a pubic hair on it, and all these different charges. These came out during the hearing, and it blew up. And Thomas called it, and I'm paraphrasing, but he called it a 20th century lynch mob. Thank you, sir. The 20th century high-tech lynch mob. Thank you, sir. That's it. The way they're going after this man, I mean, he was called an Uncle Tom. Every awful manner of speech that you could, Uncle Thomas, right? Every awful manner of speech you can imagine was charged against him. And Thomas said, this is what you get for being a black conservative. I mean, if you go back and you watch the videos, you can just see in his face the anger that he has. And no doubt that soured him to the political process. Now, he was actually able to get confirmed eventually, but the vote was close. He only had a couple votes to spare. There were a significant number of Democrats who voted against him, again, based purely on ideology. So lest anyone tell you that it's inappropriate for the Senate to consider ideology making an appointment, this has been going on for 30 years, right? This is not new. So the Supreme Court by itself can seem very happy, right? But not all the appointments go well. The next episode I like to discuss is that of this person, Harriet Miers. So the sequence of events here is somewhat complicated, but let me explain. So in 2004, Chief Justice Rehnquist was very ill, but he refused to step down. In fact, he actually stuck through the election, and he managed to swear in George W. Bush for his second inauguration. But he was very ill with cancer, and he died shortly thereafter. But before Rehnquist had died, Justice O'Connor had announced her resignation. Justice O'Connor's husband had advanced Alzheimer's, and he was, drifting away. He was even forgetting who she was. So O'Connor said she wanted to step down from the court. So initially, President George W. Bush appointed John Roberts of the D.C. Circuit to fill the Sandra Day O'Connor nomination. But after Chief Justice Rehnquist died, Bush elevated Roberts, and then Roberts was appointed to the Supreme Court for the Chief Justice seat. That still left Justice O'Connor's seat empty. So initially, President Bush nominated Harriet Miers to be the replacement for Justice Sandra Day O'Connor. Again, as if his father hadn't learned the lesson, who the heck was Harriet Miers? Okay, she was his lawyer. She was his White House counsel's office. And one of the scariest attributes of this nomination is that the person vetting Harriet Miers worked for Harriet Miers. The White House counsel vetting Harriet Miers was her subordinate. If this should give you a pause, you should not be vetting your boss for a Supreme Court nomination. The next major red flag was that Harriet Miers was again endorsed by Harry Reid and Chuck Schumer. They were like, man, must run the family, right? Making these awful nominations, right? Please clap. It went pretty bad. And it went from bad to worse because as Harriet Miers started meeting with members of the Senate and different representatives, her chance of confirmation dipped. This was the Harriet Miers-o-meter. And throughout the course of the summer of 2005, her opposition blew up. and eventually she had to withdraw her nomination. And again, I'm not trying to pick on Harriet Miers. She was a fine attorney. She was very loyal to the Bush family, but she didn't exhibit the sort of qualifications we would expect for a Supreme Court justice. So what do we learn from this, right? We have these bruising political fights. And what does this fight look like for the future? Historically, at least the last century or so, the magic number for any nomination was 60. Because of the filibuster, in order to confirm a justice, you needed 60 votes. But recently, that has changed. So throughout the Bush presidency and into the Obama presidency, the party and the minority in the Senate filibuster judges on a regular basis. This wasn't, again, based on anything other than they didn't like the judge. So because you needed 60, the party and the minority, during the Bush presidency, it was the Senate Democrats who would filibuster. And during the Obama presidency, the Senate Republicans would filibuster. Many judges were blocked who perhaps were otherwise qualified, and that is how the politics have shaken out. However, in 2013, Senate Majority Leader Harry Reid triggered something called the nuclear option. What the nuclear option says is that for all circuit and district court judges, not Supreme Court, but for all circuit and Supreme Court and district court judges, the filibuster's gone. You no longer need to invoke cloture. A bare 50-vote majority is now sufficient to put a judge with lifetime tenure on the court. Okay? There is, frankly, rank hypocrisy on both sides, because during the Bush presidency, Republicans considered the nuclear option, and Democrats said this is awful, and Republicans ultimately did not do it. During the Obama presidency, they did the nuclear option, and Republicans saying this is awful. You know, what's good for the goose is good for the gander, right? It's the exact same thing in reverse. But the consequence of the nuclear option is that now you don't need any bipartisanship to appoint a justice. All you need is a bare majority. Now, Harry Reid limited the filibuster. He said you still need a filibuster for the Supreme Court. But make no mistake, my friends, you can change that by a simple majority vote. You can amend the rules of the Senate by majority vote. If, in fact, the next president has control of the Senate, in other words, it's a Democratic president, a Democratic Senate, they will hesitate for not a second in eliminating the filibuster and appointing whoever they wish. Same for, well, I don't know. Hopefully, a Republican president and Republican Senate would do the same, but they disappoint, so I don't know. Now, the consequence of this is that elections become very significant for appointments, because it's not enough to have the presidency now to appoint a justice. In my estimation, to appoint a justice, you need both the presidency and the Senate to be controlled by one party. Now, I haven't taken these out of my presentation, but I'm going to explain this in an updated fashion. For the last 6 months or so, I've actually described the phenomenon of what I've called the Clint Eastwood theory, the empty chair theory. It's almost eerie going back and looking at my old videos of this. But for months, I've been saying there's a distinct possibility that we will have a period with less than 9 justices, where a president and the Senate will be at odds. And the president may say, or the Senate may say, let's wait till the next election. Now, I miscalculated slightly. What I had anticipated was saying there was a Republican president who appoints a justice, and the Democrat Senate blocks them. I've been saying this for months. And the Republican president may say, you know what? I'm not going to compromise on a moderate. Let's try again in 2 years after the midterm elections. What I did anticipate was that the scenario I envisioned would happen much quicker. So now here we are with a situation where there's a Democrat president, lame duck, and a Republican Senate, and within minutes of Justice Scalia's death, the Senate Republican leadership came out and said, we will not even hold a hearing. Nothing. No hearing at all. Let's wait for the next election to decide. this is more or less what I anticipated happening. It's just happening much quicker than anticipated, right? All is going as I've foreseen. I feel like Nostradamus, right? But the problem with this is we will very likely get used to a situation where if the Senate and the president are in different parties, no justice will get confirmed. This is not just a Scalia thing. This is a new precedent, and it's very easy to criticize the Senate Republicans, but I've been saying this for months. This is a natural consequence of the nuclear option. Once you eliminate the need to have any bipartisanship for judges, bipartisanship doesn't matter anymore. Once you eliminate the 60-vote threshold, it's purely a simple majoritarian act. And a necessary and, in fact, natural consequence of that is that senators will just block a justice of the opposite party. This is also a testament to the fact that the Supreme Court has become so significant and has become so enmeshed in so many aspects of our policy that this is indeed worth fighting over. You can imagine if the Supreme Court was perhaps more or perhaps less engaged in the most significant issues of our time, they wouldn't fight as much over this. But at least since the New Deal, when the Supreme Court thwarted Franklin Roosevelt's agenda, and Franklin Roosevelt tried to stack the court and appoint justices who would support his agenda. I gave a talk last week at law school where some law professor was saying, this is all Reagan's fault because Attorney General Meese was the first person who tried to appoint justices with an ideological litmus test. And I almost start laughing because this goes back to the New Deal where President Roosevelt tried to stack the courts with all these new justices who would uphold this progressive legislation. So this has been moving on a trajectory for at least the last, 80 years, 70 years. I don't know how this one winds up. Our politics right now is at a crossroads. I don't need to remind the people in this room with Super Tuesday coming up in 48 hours or 24 hours, but there may be some sort of shift or realignment in our political system that I don't know what that means. And because of the empty seat of Justice Scalia, the Supreme Court will play a central role in that realignment. I don't know where this is going. It's actually keeps me awake at night because a lot of the things that we take for granted, we take as givens, need not be taken for granted and taken as givens. A lot of stuff can change as we make America great again. So the first lesson is that these bruising confirmation battles have significance. The second lesson that I'd like to draw concerns paper trails. Paper trails are an asset and not a disqualification. What do I mean by that? We do not want justices who are blank slates, with my most sincere respects to Taylor Swift, right? We do not want justices that are ships without a sail, drifting at sea. Because when you appoint a justice without these sort of moorings to any sort of values, well, we get a justice without any moorings to any values. Even when John Roberts, and John Roberts' qualifications were doubted by none, except for Barack Obama and Joe Biden and Hillary Clinton, who filibustered him. But we don't talk about that anymore. They regret that. President Obama, through a statement, said he regretted trying to filibuster Sam Alito. He regretted that one. Okay. But even John Roberts was viewed as a strong nominee because he was stealth, that he didn't have a lengthy record. He had been a D.C. Circuit judge for about a year, not a very long time. And we simply didn't know how he thought about the Constitution. Now, he told us during his hearing, none of us were paying attention to it, but he in fact did tell us exactly how he read the Constitution. We need to know about this before the confirmation hearing. The same thing could be said about Justice Elena Kagan. She had been a law professor for a number of years. She hadn't really written much. She had written 3 or 4 articles. She'd never been a judge. She was appointed as Solicitor General for a year, which was just to keep her seat warm for the Supreme Court. And she had no meaningful record. And she, too, at the time, was the cartoon, was deemed, a stealth nominee. She had really nothing. unless we think that these hearings have any meaning. During her hearing, Justice Kagan was asked whether the Constitution protects the right to same-sex marriage. She said, absolutely not. Okay, well, I mean, she changed her mind, I suppose. Justice Sotomayor was asked during her hearing, is District of Columbia v. Heller, the Second Amendment decision, is that settled law? She says, yes, it's settled law. And a year later, McDonald voted to overturn it. So these hearings are worthless. And it makes it even worse because these justices have no record to challenge them on. Sotomayor actually had a record. She was a judge for nearly 2 decades. But Kagan did not. Indeed, one of the pejoratives given to people like Kagan is the Little Supremes. Anyone ever hear of this? Little Supremes. This is the idea that these are people who from their youngest ages want to be justices. So they shape and mold their entire existences for the sole purpose of not having anything to disqualify them at a confirmation hearing. This is Kagan's high school yearbook photo and her quotation for Felix Frankfurter. I didn't know who Felix Frankfurter was in high school, but she did. She's much smarter than I was. And she said, government is itself an art, one of the subtlest of arts. And this is actually Sam Alito's yearbook from Princeton. And this one's hard to read, but it says, Sam intends to go to law school and eventually to warm a seat in the Supreme Court, which I suppose is fairly prescient. But I think we need to think carefully about these people who shape their entire lives to be justices. And I quote from Pam Carlin, who's a law professor at Stanford, who's quite liberal. I mean, unabashedly liberal, but I'm a fan of hers. And someone's asked her, would you like them in the Supreme Court? And she said, you bet I would, but not enough to have trimmed my sails for half a lifetime. In a lawyer, courage is a muscle. You develop courage by exercising it. Sitting on the fence is not practice for standing up. Imagine what it takes to live your entire life to be a justice in waiting, right? We need people with courage and backbone who can resist the forces of this town, of Washington, D.C. I realize we're close enough to the Potomac that maybe you can see some of it wafting down, but it's a dangerous place to live. Unless we forget Chief Justice Roberts. This was Glenn Beck charging him as a coward after the Obamacare decision. If you notice, Chief Justice Roberts often cites Chief Justice Marshall, he views as his icon. I am not a Marshall fan. With respect to Virginia, I know he's a native son. I think he was a lousy justice. I think he's vastly overrated also. His opinions were not grounded in law. He made stuff up. He had political aspirations that were very detrimental to the Constitution, but not a Marshall fan. I think we need less John Marshall and more James Madison, another Virginian whom I do like very much more than Marshall. The third lesson discusses what might be called judicial restraint. And I think we need to be very careful about this meme. At least for the last 30 years, every single judge says, I am not an activist, I am restrained. And this doesn't really mean anything. These are phrases that have no substance. And they have no substance because very often the Constitution demands a judge to be engaged, if you will. And perhaps the most perfect example of this is Obamacare. The first book that I wrote was on the constitutional challenge to the Affordable Care Act's individual mandate. And I like to contrast the opinions of the 2 Bush nominees. So what's interesting about the Obamacare decision is that both Bush nominees, Sam Alito and John Roberts, agreed that the individual mandate could not be justified under the Commerce Clause. There was a regulation of inactivity. Both Chief Justice Roberts and Samuel Alito agreed that you cannot justify the Affordable Care Act under the necessary and proper power. Both Samuel Alito and John Roberts agreed that Congress did not write the Affordable Care Act as a tax, that they wrote as a regulation of commerce. Where they departed is that Chief Justice Roberts said, in order to avoid invalidating this law, I will pretend Congress wrote it as a tax. I will rewrite the Affordable Care Act such that the ACA is in fact a tax. Even though the political branches called it a penalty, they said this is not a tax. The chief said, we have a duty to uphold the law. Justice Alito, who was in dissent with Scalia, Kennedy, and Thomas, said no. If this is unconstitutional, strike it down. Now, who here is the activist and who here is restrained? It may not be what you think. Roberts rewrote the statute. A more activist act I cannot fathom. He rewrote the law. The ACA we have now is not really even SCOTUS care, it's really Roberts care. We have a situation, like in Virginia, for example, where there's no Medicaid expansion, right? What did Roberts say? If a state wants to expand Medicaid, they have to. If they don't, they don't. We're living in this weird world. The ACA is not even functioning as it should have because the chief decided to rewrite provisions of it. He did it again in KV Burwell last year. The law says subsidies are available in exchanges established by the states. The Chief Justice said, well, that means any state, federal or state, doesn't matter. So we're living in a world of John Roberts' making. We have Kennedy's world and Obamacare's Roberts' world. These are not judges calling balls and strikes. These are judges throwing curveballs. And we need to guard against this. A book I'd commend to you is called Terms of Engagement by Clark Neely. He's a lawyer at Institute for Justice. And I think he makes a fairly compelling case about why these calls for judicial restraint are misguided. The fourth and fifth lesson, which I'll go through quickly so we have time for questions, is we need to focus on the Constitution and not where the issue du jour is. And what do I mean by that? No one, when John Roberts was being nominated, could have anticipated Obamacare. Right? No one was going to ask him, can Congress make you buy broccoli? Although fittingly, they asked Kagan that, and she said no, but that didn't hold up very long. When President Clinton's nominees were being put up, no one could have anticipated that the defining issue of the next 8 years would be Guantanamo Bay. Right? We didn't anticipate this was coming up. No one anticipated Bush v. Gore. It's very easy in hindsight to look at a judge voting one way or the other in a case, and we don't know why they did it. But we can't anticipate in advance what the next big issue will be. I respectfully submit we need to move away from these so-called litmus tests, right? How will a judge vote on one issue? How many people have been giving a litmus test in Roe v. Wade, and how far has that gotten you, right? I don't want to hear litmus tests on Roe v. Wade anymore. I don't want to hear litmus tests in Citizens United, even though Hillary Clinton and Bernie Sanders have both said they'll impose one. I don't want to hear any litmus tests on a Obergefell, the gay marriage decision. Focus not on these issues, but on the Constitution itself. And how does the judge go about interpreting the Constitution? And what is the role between the courts and the other branches? That is a much more fertile ground to ask about. And the final lesson, I think this one may actually make the confirmation hearings less awful, is instead of asking about cases, ask about clauses of the Constitution. So I gave you this example before. Sonia Sotomayor was asked during her hearing, what do you think about the Second Amendment? And she said, well, District of Columbia v. Heller is settled law. Do you agree with it? District of Columbia is settled law, right? She keeps saying that's settled law. That tells you absolutely nothing what the nominee thinks about the Second Amendment. Nothing, because not even a year later in the case of McDonald v. City of Chicago, her dissent, which she joined, effectively said Heller was wrong. So justices are not actually bound by stare decisis. They're not. Asking a justice nominee about a case is worthless. But how about you ask them about a clause of the Constitution? You know, discuss for us the original meaning of the Second Amendment. Oh, right. Discuss the original meaning of the 14th Amendment. How did the framers understand the Commerce Clause, right? Asking the question differently, they can't dodge it. They can't say, well, you know, that's a case that may come before us. Well, ask about history. What did James Madison think about this, right? They'll either answer the question or show their ignorance. I don't know. But perhaps this is one way of actually making the entire discussion more formative. These are some tips to think about when selecting the next justice. This is a decision which, though I fear, will not be made under the most hospitable terms. Any day now, President Obama will likely make a nomination to the Supreme Court. And if the Senate Republicans do what they said they're going to do, this person will get no hearing. So then November comes, and a couple of things can happen. So first of all, it's possible that a Democrat president wins and a Democrat Senate wins, in which case President Hillary Clinton will probably nominate whomever she wants and get confirmed to whomever she wants. What happens if it's a Republican president with a Democrat Senate? Well, this will scare you, and your stomach may turn. This is what's called the thermonuclear option, if you will. So under the Constitution, the Senate meets on January 3rd. The new Senate meets on January 3rd, 2017. The new president comes on January 20th. There's actually a 17-day period where Barack Obama will still be president, and there may be a Democrat Senate. The thermonuclear option is that they ram a justice through in 17 days. If there's a Republican president coming in and a Democrat Senate comes in, they can actually appoint a justice in 17 days. They have to blow up all the rules, but I don't think they would care at this point, especially after the Republicans blocked the hearing for 8 months. The third option, which should be the most comforting, but it's perhaps the most scary, is what happens if there's a President Trump and a Republican Senate. I have no idea what happens. I have no idea what happens then. I mean, I noted I'm supporting Senator Cruz for presidency, but it may be worth thinking about whether President Trump makes a deal in the Supreme Court. You know, give me a border wall, I'll give you a justice. I don't know. You can think whatever it is. And the lesson that I've tried to teach throughout this entire presentation is the Supreme Court is not something we should be negotiating over. This is now the prerogative of the president. And whatever short-term gains you can get by building a border wall or, I don't know, building a border net to stop Zika, whatever it is, right? A justice lasts for 30 years. This is not something to be trifled with. And I hope and I pray the next justice, so the next president, takes this obligation as seriously as it ought to be taken. Thank you so very much. And I'll ask questions, but thank you so much. And I'd be happy to take your questions.
What about this option? If Cruz doesn't win in Texas and his campaign has to fold, perhaps he makes a deal with Trump. Trump becomes president. Cruz gets nominated.
Yeah, I mean, I've heard that. I think Senator Cruz would be a wonderful justice. I don't know if he wants to be a justice, though. And I'll give you an analogy. So by history, Hugo Black, one of the most long-serving justices, was an Alabama senator. Why did Franklin Roosevelt put Hugo Black on the Supreme Court? To get him out of the Senate. Can you imagine? Hugo Black was a thorn in Roosevelt's side. So you know what? I'm going to get rid of him and put him on the Supreme Court. Give you another example. William O. Douglas was a long-time Supreme Court justice as well, 30-something years in the court. Douglas had long-time aspirations to become president. He always wanted to be president. And at several points, he considered resigning to run for the presidency. I don't know if Justice Cruz would want to serve 30 years in the court. He may, again, want to be president.
He's young. He's definitely conservative, ideologically correct to a lot of people. And there's a precedent by nominating and having somebody approved as a justice. Kagan has never been a judge. He also has a lot of experience in the Supreme Court.
Well, Cruz had far more experience. Elena Kagan never argued a case until 2009. Citizens United was the first case she's ever argued for any court ever. She lost. She lost, which is fine.
It never would have come to that if Obama had not broken his word in 2008 election and taken the other money like he said he would. He's the one who created the Citizens United mess, but he's avoided any responsibility for that. Now, the real question I wanted to get to you. I have heard that during the Clarence Thomas nomination, that certain women's groups went to Biden and said, you know, we're going to save this guy. We've got the evidence right now. We went to these X-rated movie rental places and found that he had records renting X-rated movies. We want you to introduce that as evidence. And supposedly Biden declined that, which I think is a good thing for Biden.
Yeah, so with respect to Biden, I mean, I joke about him probably more than I ought to, but it could have been worse. He could have simply said, because the thing was, Anita Hill stuck him out during the hearing. He could have simply said, you know what, we're going to cancel this hearing, hold a new one next month. And that would just blow the entire thing up. So with respect to Biden, he actually, I think, he wasn't a saint, but he could have been worse than Justice Thomas. But he actually did let them through. So yes, you're right. Yes, sir. Either one.
Go ahead.
On the subject of you being kept up at night or awake, from the perspective of a non-attorney, but I like to think I'm a keen observer of America. Aren't we really saying that you're being kept up by the thought that America has crossed over into a third world judicial system?
I think, I mean, to be frank, I think that what's keeping me up is the uncertainty. Because even though the Supreme Court has maybe gone a little bit to the left or a little bit to the right over the last 30 years, it's been more or less following a trajectory. I don't know what this trajectory looks like in 10 years. Because, simply stated, if the new norm becomes that you only have justice confirmed where the Senate and the president are the same party, we very well may have positions where we have less than 9 justices for extended periods of time. You actually see this on state Supreme Courts, like the New Jersey Supreme Court, for example. They've had empty seats for like years. So our entire notion of a 9-justice court may become up in the air. And because then getting a justice becomes so important, the fights over them become more contested. And nominees who maybe should be considered because they have qualifications are ignored because they're going to be too controversial. So I don't know what this looks like in a decade. Yes, sir. Go ahead.
But isn't this, aren't we in territory where we're definitely seeing a quote unquote protected class that, I mean, it's in many instances, you're looking at a lawless regime and a lawless class of individuals. Taking the headings off of emails and stripping out the secret, the top secret, SAP emails so that you can trade them over the handheld devices. It's to me, non-attorney. It's just it's selective enforcement of our laws.
Yeah. Well, one question at a time, please. Well, yeah. Yes, sir. Question?
Well, the way I look at this, we have 2 different problems. We have created a court, which is immensely powerful, and which advocacy groups have learned to use to get things done judicially that they can't get done legislatively. But then on the other hand, you've got the vast amount of the American people who 2 years ago, 2/3 of the of those surveyed couldn't name a single justice on the Supreme Court. Until Scalia's death, I would bet you that was still true up until a couple of weeks ago.
Mm-hmm.
So we've got this great chasm. American people seem to be completely detached from what the court does. But yet there's a significant population of advocacy groups and people in the political process who have rightfully decided the court is where they're going to achieve their victories. How do we deal with this vast divide that I see?
So I think your question is well taken. The reason why the Supreme Court has become such a big issue is because the Supreme Court is such a big issue. Every year, every June, without fail, the biggest issues of the day are being resolved by the court. Obamacare, marriage, the scope of federal power, states' rights, the Second Amendment, guns. The court has become enmeshed in all these issues. And I don't know that's necessarily a bad thing. I think the reason why the court has become enmeshed in these issues is because the government has begun doing more stuff that they probably oughtn't do, right? If the government was acting in a more constitutionally faithful manner, you wouldn't have the need for the court to be so engaged. But because we have a growing Leviathan in government, combined with the political branches not being able to check that power, it has fallen, for better or worse, the courts to try to enforce the Constitution. And whenever they issue a decision, it makes half the country unhappy, right? So the court upholds Obamacare, half the country loves it, half the country hates it, right? They issue a decision on gay marriage, people love it, people hate it. They issue a decision on the Second Amendment, people love it, people hate it. And that takes a toll after a while. I think the Chief Justice has tried to make this point. I don't agree with him, but he's made the point that the court should not be seen as a purely ideological beast. We have 5 Republican justices and you have 4 Democratic justices, and they vote however they ought to vote, which is why I think that the Chief Justice voted the way he did in the Obamacare decision. Tessa?
So you said at the beginning, this maybe gives more to your talk at noon, but you're concerned about Chief Justice Roberts breaking your heart again this year. Is there anything in particular you think that he's going to go crazy on?
Yeah, so my fear with the Chief Justice is he will try to avoid the appearance of a lot of 4-4 ties, and I'll talk later at Region about the specifics, but it's very easy for Robert to simply just get rid of each of these cases that are pending, all the big ones on affirmative action, on abortion, on immigration, on free speech. He can get rid of these cases pretty easily, and he can be the decisive 5th or even 6th vote. So he's probably going to break my heart on immigration. He may even break my heart on contraceptive mandate. I don't know, but he breaks my heart every year without fail. I feel like I'm this jilted lover, right? What's it, Stockholm syndrome, where I keep going back to my captor because I need him, but he breaks my heart. Yeah, I'll be at Region at noon if anyone wants to comment.
What is it?
Well, I'm talking about the Supreme Court term, and specifically how Justice Scalia's absence will affect a number of these cases. I have to still figure it out because this is somewhat new, but that'll be the gist of the talk.
How do you think it's going to affect the
McDonald?
McDonald case?
Which one?
Bob McDonald.
Oh, poor Governor McDonald. Yeah, no, he's screwed. I thought he had 5 votes, but I only gets 5 votes anymore. I'm sorry, Rob McDonald, right? Yeah, no, respectfully to the former governor, I don't think he has 5 votes anymore, and a 4-4 tie affirms his conviction.
Getting to what this gentleman was touching on, the scuttlebutt is that there's almost an open revolt within the FBI because they're so certain that the evidence is there to indict Hillary Clinton. But the scenario that I've heard is it goes up to
James Comey.
No, the Attorney General.
Lynch.
If Comey recommends to indict and Lynch decides not to indict, there is talk there's going to be a lot of people resigning from the FBI.
I mean that's beyond my expertise.
Well, the reason I bring that
yes.
up is because if you think back to the Nixon administration, Saturday Night Massacre.
Yes, sir.
Really, in my estimation, what happened during the Watergate is none of the organs of government that we're used to could check the executive branch. And it even went through the judicial branch. The only thing that stopped Nixon from taking over the country illegally was the state. And for years, I believe this swelled their heads so much they were willing to affect the media at large, and investigative journalists were willing to lie their butts off to get what they wanted. Case in point was a famous case of somebody who won a Pulitzer Prize for writing a series of articles about an inner city youth in Baltimore who had such a tragic existence, never existed. Admitted later on that he made the whole thing up. And journalism professors were happy to say it's okay because it was for a good purpose. Well, as I've touched on with some folks here, the founding fathers said there are 2 things necessary for the country to succeed: a moral population and accurate information from the base of decisions.
Very good.
They're no longer getting accurate information.
Thank you, sir. Any other questions? Well, thank you so much. I'm grateful again for Chris and Elizabeth, and I hope you guys have a wonderful day. Thank you.
Thank you, Professor Blackman. And apparently, the 12 o'clock talk at Regent is available, so I'll put a test on that. Thank you all for coming. The idea of checks in the government is something that we're very focused on. This is an issues-based organization, so one of the talks we're looking at happening, maybe in a debate format, is the role of states' attorneys general in really asserting province and states where they feel the federal executive may have encroached. So look forward to that in the future. And thank you so much for coming out. I know if you signed up, you'll get some emails. I think the response emails you get from us, our Facebook page will be on there, so take a look. We'll be posting some things soon. Thank you so much.
Thank you.
And if you're able to say your feedback, let us know.